eradicate and suppress terrorist attacks that continues to permeate the country, making it hard for the government to secure its citizens. 2 points of rebuttals. First, activism is not terrorism. As enshrined in Section 4 of the Anti-Terror Bill, advocacy, dissent, protest, and other similar exercises of civil and political rights are not terrorism. In Section 29 thereof, the determination of the extension of the detention still remains with the courts. Your Honors, this House recognizes the beneficiality of the Anti-Terror Bill. We firmly believe that now more than ever, the Philippines is in need of an iron hand that could stop and eradicate terrorist attacks to save our citizenry and the identity of the Bangsamoro from the devastating effects of terrorism. First point, security of the nation is of utmost importance. In the 2019 Global Terrorism Index, the Philippines is the only Southeast Asian country which ranked in the top 10 most impacted by terrorism. This includes the destruction of life, liberty, and property. In the Bangsamoro region, this land suffered and continues to suffer from the terrors of this terrorism. From 2000 to 2012, there were more than 25 grenade attacks that this region suffered. This leads me to my second point. The identity and development of the Bangsamoro and the Philippines had greatly been affected by these acts. In 2010, the Philippines have been dubbed as haven for terrorists. The military publicly revealed that there were around 50 foreign national terrorists operating in Mindanao. With the advent of the Anti-Terror Bill, this will provide a comprehensive approach together with the peace process in addressing the root cause of terrorism. The Philippines will send them a message that the government is in the fight against terrorism.
Are you aware of Article 3, Section 1 of our Constitution?
Yes.
Isn't it that under Section 25 of the Anti-Terror Bill, the ATC has the power to designate individuals
Nowhere in the bill,
Please respect my time and answer yes or no.
Continue.
It is sufficient to rely on the personal knowledge of the authority to find probable cause and
The
subsequently
authority
not only
right does
the
not
suspected
warrant
orders but also
arrest.
declare the
It is
right
still
of
within
terrorist.
the
Yes or no?
discretion of the court.
Yes or no, counsel?
It is still within
Yes or
the
no,
discretion.
counsel?
No.
Then would you agree with me that the due process means a hearing where an individual can present his side to rebut the allegations against him?
Yes.
Yes.
That is
Yet
the
under
process.
Section 25 of the bill, ATC can tag anyone as a terrorist without being given the chance to
Counsel, the
explain
order of
clearly a
detention
violation
does
of the
not
right against the
order
privilege of
of
the people
arrest.
without due process. No further questions, Your Honor.
Now, ladies and gentlemen, before us is the proposition that whether or not the Anti-Terrorism Act of 2020 is unconstitutional. We on the affirmative side strongly believe that it is not only unconstitutional but also a law of terror. This bill is not only unnecessary and non-beneficial as previously presented, but also impractical. Why? First, the withdrawal of support from the lawmakers. It questions the honesty and quality of the lawmaking process. As of June 9, some of them have already withdrawn their votes, stating that they did not have enough time to study the content of the bill before the vote. Not to mention, all amendments to the bill were all rejected. Second, the absence of proper stakeholder consultation. There is no mention of LGU or CSO participation or any consultations in making high-level decisions. Proper consultations with stakeholders must have been made to give a more comprehensive picture of the possible actions that should be taken. Lastly, Anti-Terror Bill removes Section 41 of the Human Security Act of 2007, which gives to suspects who are adjudged to be acquitted for the crime. Safeguards must be deliberately set in place to avoid grave abuse of discretion. This is true in a number of cases here in BARM, where incidences of mistaken identity and tagging of our Islamic schools as training grounds for terrorists still continue to exist. In our present law system, if the judge believes that you have not committed any crime, he cannot issue a warrant of arrest. But with Anti-Terrorism Act, to quote Senator Lacson's words, hindi pa nangyari, nasa simula pa lamang, pwede na nating arestuhin. This is a dreadful law not only for the actual terrorists, but for everyone. Why? Anyone can be arrested out of mere suspicions only. Anyone can be designated right away as a terrorist without being required hearings to defend himself. Or maybe you will be house arrested even if you are entitled to bail. Or imagine being detained for as long as 24 days even without being charged of any crime. Even the rate of habeas corpus would not be much of help in this situation. The courts may require the custodian to justify the detention, but all the custodian needs to do is show the written authority of the ATC to the judge, then the judge will be compelled to dismiss the petition. Assuming that authorities could not gather enough evidence within 24 days of detention, there is no provision in the bill regarding rearrest. After a few days, he can be arrested again, and the 24-day cycle will keep on repeating. We hope none of the Filipinos will be a victim of repression or worse, life imprisonment just because they have been wrongfully tagged as terrorists. To our Bangsamoro brothers and sisters, we have always been a subject of generalization and misjudgment. Imagine living in a country where every step we take scares us, knowing that we are being monitored by a state agent who is lawfully authorized by the state, when our only crime is being a Muslim. Again, we have given you different arguments. All are aimed at the same point. Anti-Terrorism Act is unconstitutional. No matter what the opposing bench said, they cannot seem to prove their points nor debunk ours. It is with this that we politely yet confidently rest our case. Thank you very much.
Simple, Council. Are you aware of how legislation is passed?
Yes.
Thank you. Now, moving on, are you aware that there should be grounds for the power of legislation, especially here in the anti-terror bill?
Of course.
Exactly. Now, okay, the question is, are you aware of these tests and standards?
Yes.
Oh, very well. Ladies and gentlemen, in Inchok versus Hernandez, the test and standard for legislation must be firmly grounded on public interest and public welfare. It is nowhere found in the Constitution that fear of abuse will declare unconstitutional. That is the point, Ms. Speaker. Now, is it in your position that terrorism is not a public interest? Is it in your position that terrorism is not a public interest?
It is a public interest.
Terrorism is a global predicament, and no nation is invulnerable to it. Good evening and assalamu alaikum. Allow me to rebut 2 points. First, the fear of abuse of the affirmative is wanting in this case because the fear of abuse is not a requisite of legislation. Second, in Section 45 of the Anti-Terror Bill, it is unequivocal because the fear of affirmative does not hold water. The Anti-Terror Council shall not be empowered to have a quasi-judicial or judicial power or even the power of being an executioner. As the last speaker of this Bangsamoro debate, allow me to argue on the practicability of the anti-terror bill. First point, the bill was crafted in conformance with Section 4, Article 2 of the Constitution that states the prime duty of the government is to serve and protect the people. As seen in Section 2 of the Senate Bill 1083, or the anti-terror bill, it is directed to create measures in conflict management, post-conflict peace building, and promote economic development. Ladies and gentlemen, the letter and intent of the law is simply but noble. The Philippines will be exercising its constitutional right to implement necessary actions, which is also in keeping with the United Nations Security Commission Resolution 1373 and 1624 that directs countries to adopt necessary measures against terrorism in accordance with their legal obligation under international law. Thus, the birth of ASEAN Convention on Counter-Terrorism of 2007, and ladies and gentlemen, Philippines is a signatory. In Article 6 of the said convention, it laid down operation in which the anti-terror bill also resonates. First, to take necessary steps to prevent the commission of terror acts. Second, to prevent those who finance, plan, facilitate, or commit terrorist acts, which leads me to my last point. Terrorism knows no religion. It knows no race. It should be faced head-on with a strong legal structure, and that is the proposition of this bill. The Bangsamoro is facing a new breed of mutating terrorists, which the anti-terror bill aims to eradicate. It has been to the submission of the affirmative house that the Bangsamoro people will be mostly affected. That this will help in establishing our Bangsamoro identity. If the affirmative house have scrutinized the bill, in Section 45 of the anti-terror bill, the Chief Minister of BARD and NCMF, among others, shall serve as support agencies of the very council. This will help unveil those who are falsely using the banner of Bangsamoro. This will help in exposing those who are wolves in sheep's clothing. But again, ladies and gentlemen, with the promise of fairness and always due process. Thank you. Assalamualaikum.
Do you agree with me that our Constitution, being the highest law of the land, shall be inviolable for any purpose and at all times?
Of course.
Good. Isn't it under Article 3, Section 2 of the Constitution, no warrant of arrest shall be issued except upon probable cause which shall be determined further? It's just a yes or no.
It's probable
Yes.
cause.
Isn't it ma'am, third question? Isn't it under Section 29 of the Anti-Terrorism Bill? It was explicitly stated that any law enforcement agent can legally take custody of a person suspected of terrorism,
Yes,
provided
if you have
provided that they have been duly authorized and Yes or no?
Yes, it is written in the
Isn't allowing the ATC, who is not part of the
And
judiciary,
yes,
to issue an authorization for non-respect my time.
Judicial power.
A clear violation of what the Constitution has only allowed.
No. The
Ma'am, the
anti-terrorism
question is ATC part of the judiciary? Ma'am.
No! The ATC is not part of the
Section
judiciary.
29 did not only
Section
overstep
45,
into
it
the
is not
non-respect my
judiciary.
time.
It is
Section
not
29
part of
did
the
not only
judiciary.
overstep into the court's
It is
decision,
not part of the
but also
judiciary.
allows the
Thank
judiciary.
you. The third speakers of the both houses.
We hope that we have presented to you the various arguments on both sides, although we would like to remind you that the kind volunteers that we had from who are students of law had volunteered to be debaters. So the arguments that they had presented and the examples that they had given in no way represents their personal convictions or their side. They had presented it as students of debate to present the various sides of an issue that is dividing the nation. We hope that this will inspire more of the youth and the students to continue the practice of debate so that we will have more volunteers for the next episodes of the Bangsamoro debates. Till next time.
Assalamualaikum. Welcome to the Bangsamoro debates.
They protested against the supposed railroading of the proposed anti-terror law of 2020, which now only needs the signature of President Rodrigo Duterte.
You have heard the critical issues argued on both sides on the constitutionality of the anti-terrorism bill.
The Philippine government is at the verge of adopting a new anti-terrorism law. Essential feature of this anti-terrorism bill that was passed by our bicameral Congress, this anti-terrorism bill seeks to enhance and strengthen the state's policy against terrorism. It aims to recalibrate the approach of the Philippines against terrorism by amending or even repealing the existing HSA or the Human Security Act of 2007.
This is an initiative that is not strictly bound by the technical rules of a formal debate, and so we do not strictly adhere to the rules of a formal debate.
Welcome to the Bangsamoro debates.
For the mechanics of tonight's debate, we are using the modified article and Oxford debate format. The debate is between the affirmative and the negative house with 3 members each. Each debater from the affirmative house argues on the necessity, beneficiality, and practicability of the proposition. The counterpart debater opposes these arguments. Each debater is given 3 minutes to deliver its constructive speech and 1 minute to interpolate or cross-examine the counterpart debater. First off, from the affirmative side, we have Fahad. Fahad, you have 3 minutes to tell us why is it necessary that the bill is unconstitutional. Your 3 minutes starts now.
Terrorism has been a very familiar problem our country is facing in every administration, including the current ones. The names changes, but their actions do not. As much as we would like to eradicate it, we must do it legally. It is an elementary rule in lawmaking bodies how imperative it is to stay within the Constitution in making legislations. Ladies and gentlemen, on the issue of the unconstitutionality of the anti-terrorism bill, we affirm such. The anti-terrorism bill is unconstitutional. Laws must define the crimes that they seek punishment for as clearly as possible. Ambiguity and inexactness of the definition of terrorism in the bill negates such. It can be used to achieve certain ends that do not necessarily protect people's welfare, nor maintain the integrity of the Constitution. In the case of Romualdez versus Comelec, the void for vagueness doctrine was applied. The doctrine holds that a law is facially invalid if men of common knowledge must necessarily guess at its meaning and differ as to its application. That is not such a law. The former Justice Carpio himself, an interpreter of the law, has expressed his concern on the vagueness of the definition of terrorism, specifically in Section 4 of the said bill. The Anti-Terror Bill also attacks our right to dissent. The bill provides a leeway to target criticism and dissent instead of actually solving the problem of terrorism by having provisions that makes the line between activism and terrorism unconscionably thin. This bill results in the chilling effect in which the people would rather not dissent in fear of being branded as a terrorist. In the case of Dicini versus Secretary of Justice, the Supreme Court ruled that when a law encroaches upon the freedom of speech and expression of a person, a facial challenge on the ground of void for vagueness rule is allowed. On its susceptibility to abuse and the reliance of judgment calls made by the ATC, law enforcement agent or military personnel can simply claim good faith on their duties. We always hear them say, "I am not a terrorist. Why should I be afraid of the bill?" Well, if this bill becomes a law, it will make you one, even if you're not. That would be all. Thank you.
Do you recognize the necessity of striking a balance between national security interests and the fundamental rights?
Definitely.
Very well. So are you with me that the anti-terrorism bill is contrary to the Bill of Rights?
No, I think not.
So you are discrediting the Section 2 of the said bill in accordance with the Bill of Rights, specifically freedom of speech and civil liberty.
But then again, there are provisions
No,
that
Counsel.
contradicts
My
the
third
free
question,
expression
Counsel. Please
of the
respect my time. I
citizens.
have my next question, Counsel.
Okay.
So, Counsel, are you with me that the prime duty of the government is to serve and protect the people?
Definitely yes.
Yes, thank you for your concession and no further questions. 2 points of rebuttal. In Viraga versus Philippine Truth Commission, the vagueness was not considered a valid reason to strike down the law. Second point, it was declared in Chavez versus Gomez that the freedom of speech and the freedom of expression was not absolute. It will yield to the national security. Now, as the first speaker of this House, allow me to establish the constitutionality and the necessity of the anti-terrorism bill. First, Section 4, Article 2 of the Constitution states that the prime duty of the government is to serve and protect the people. Clearly, the right to protection is a constitutional mandate. It has been 3 years since the tragic Marawi siege. Until now, however, terrorist attacks continue to permeate the country, making it hard for the government to ensure safety among its citizens from those who persistently seek to destroy our motherland. This is the situation in the Philippines. Second, presumption of constitutionality. Unless otherwise declared by the Supreme Court, this bill enjoys the presumption of constitutionality. Even if some provisions may be declared to be unconstitutional, the entire bill does not succumb to be unconstitutional, as such is protected under the separability clause provided in Section 55 of this bill. In Imwong versus Ochoa, some provisions of the RH bill were unconstitutional, but the entire bill itself is constitutional. Third, the anti-terrorism bill is the improved version of the Human Security Act of 2007. This act has proved to fail in terms of its efficacy as the anti-terrorism measure, probably because it's lenient to offenders and restrictive to enforcers. The DOJ Task Force on Anti-Terrorism secures only 3 convictions on terrorists for more than a decade. Fourth, the popular majority in the Philippines is not unaware of the dangers of terrorism. They are even taking advantage of the COVID-19 outbreak. Even the lockdown did not stop terrorism. According to Harry Roque, 6,000 residents of Maguindanao have abandoned their home because of terrorist attacks, while 11 soldiers were killed in the Sulu attack. Now, more than ever, it becomes imperative for the government to effectively respond not only to the threats of terrorism, but also not only only to the challenges posed by COVID-19, but also to the threats of terrorism.
Are you familiar with the Rule 113, Section 5 of the Rules of Court pertaining to warrantless
Of course,
arrest? Under Rule 113, Section 5, any law enforcement agent can effect a warrantless arrest only for urgent cases where the crime is happening almost at the moment of an arrest. Yes, correct? Okay. According to the authors of the bill, warrantless arrest under Section 29 of the Anti-Terror Bill is pursuant to Rule 113, correct? Okay, so if that's the case, Section 29 of the Anti-Terror Bill would be senseless because warrantless arrests are allowed only if it has been duly
No,
authorized
I guess you
by
are
the
mistaken.
ATC
You are mistaken,
in
Counsel.
writing. Not
Section
this
29
answer yes
is in
or no.
accordance.
This is
No,
my
it
time
is in
because I
accordance.
have another
No,
question.
but please allow me to answer.
You cannot arrest upon a person during urgent situations if you still need to secure the written authorization of the ATC.
I guess you are
Can
mistaken. I guess you are mistaken.
No, ma'am.
The role of the ATC is only a written authorization and not a order of arrest.
It's the firm stand of the affirmative bench that the anti-terror bill is unconstitutional lest its vague provisions are non-beneficial. Contrary to the first negative speaker's argument, certain overbreadth and ambiguous provisions of the ATB creates more opportunities for misinterpretations, maltreatment, and even extrajudicial enforcement of authority. A very valid reason to strike the law. Section 10 of the bill penalizes the recruitment and membership in a terrorist organization. We argue that this stifles the very essence of democracy and rights guaranteed by the Constitution. PBM versus Philippine Blooming Mills provides that the rights of free expression, free assembly, and petition are also political rights essential to man's life. Unlawful privacy invasion. Ople versus Torres states that the governmental powers stop short of certain intrusions to the personal life of a citizen. Under ATB, even persons merely suspected of committing acts in violation of such can be served upon, giving wide discretion in favor of law enforcement. Lawless warrantless arrest. Section 3 of the ATB demolishes the inviolable right against unreasonable searches and seizures. In People versus Marty, the constitutional prescription against this right applies as a restraint directed against the government and its agencies tasked with the enforcement of the law. In contrast, Your Honors, the bill allows law enforcers to search and record communications of suspected persons without the presence of a warrant. Section 17 of the bill grants judicial authorization upon probable cause to believe that the evidence will be obtained later on and not for the evidence available during such determination. Your Honors, our law requires that before issuing a warrant, the existence of probable cause should be determined by the judge. This entirely places the subject into the arbitrary detention or determination of an offense and gravely violates his right to due process. Section 25 of the ATB allows the Anti-Terrorism Council to designate any person as a terrorist and allows the Anti-Money Laundering Council to freeze the assets of this designated as such without even giving the aggrieved party an opportunity to submit a countervailing evidence to prove his side. Your Honors, this bill also amounts to a bill of attainder for it inflicts punishment without a trial. Section 29 allows ATC, an executive body, an authority to determine for itself if there are sufficient grounds for prolonging a person's deprivation of liberty. Only a judge can issue a warrant of arrest. Angara versus Electoral Commission was clear that the principle of separation of powers is a fundamental principle in our government. It further demolishes the warrant of arrest upon probable cause. From the principal author's own words, you can be arrested if you still did not commit the crime on the justification that the authorities would want to be proactive. Your Honors, we find that the seeming benefits of the anti-terror bill do not offset the necessity of its enactment. Thank you.
Good evening, Counsel.
Good evening.
Are you with me that terrorism is